Hello, everybody. Can you believe it's already time for another talking point? So I guess it's true what they say that time flies when you're having fun. And we definitely have been having fun helping ordinary people learn how to become savvy business investors. And that is why you are here, to learn and to expand your knowledge on all things property, investment, and trusts. Now, today's topic is a little bit of a somber one, but it's vitally important to have this done correctly in order for you to ensure that you are leaving behind a legacy for your future generations. So listen up, let us help you make sure that you've got your affairs in order. So today we're going to be focusing on estate planning, and in particular, the relationship between the estate and your trust. So joining me today is one of our legal experts from Treasury Trust Services, Marishka van Sale. So thank you so much for taking the time to join us today, Marishka.
Thank you so much for having me, Damien.
Brilliant. Now I'm going to jump straight into the questions. So for those who may know, we send out our Times article every week on a Friday. And there's an opportunity for you as your readers to send us some questions. So we've got a couple of those compiled, and we're just going to run through a few of them. So make sure you have your pen and paper ready, pay attention, and we'll give you some more details later. So Marishka, for those who may not be aware of the process, can you give us a brief rundown of what happens legally to someone's estate when they pass away, and what steps are taken to wind up the estate?
So the first thing what we do as executor, we arrange a meeting between the remaining family and the surviving spouse. Now, at this point, the executor will determine whether this person's estate is a 18-free normal estate or whether the person has a will. Now, the 18-free estate, this is an estate of 250,000 or less. And in this estate, the process is a bit different than an estate of 250,000 or higher. For example, you do not advertise this estate, nor do you compile a liquidation and distribution account, but it can still take time to administer. And when a deceased doesn't have a will, that's the first thing you ask for is whether the deceased have a will. You have to nominate an executor, and your estate will dissolve according to the Interstate Succession Act. So in these meetings, the executor wants to gather as much information as possible. After you lodge the documents, you will receive the letters of executorship. You start by opening an estate bank account. All the funds of the deceased personal estate will then be transferred to this estate late account. The executor will start to collect all assets and liabilities, and this is in order to compile the liquidation and distribution account. Now, it is only after this account that you really see how much is the estate duty, the executor's fees, and just how much you are paying to have this estate administered.
So, Marishka, now what are the risks involved if you do not have a plan in place for your estate?
Well, I would say the number one risk is the high cost payable, which includes the executor's fees as well as the estate duty. If we look at the risk of not having a will, people can inherit that you wanted to exclude in the first place. Because if you look at the rules of the interstate succession, in order to distribute and dissolve the estate, they take into account children, and that is children you might not even know of. So that is quite a big risk. And another one is if you have a trust and all the assets on your personal name, you run the risk of losing these assets because in certain cases, the executor will sell these to pay the creditors in a deceased estate.
And Marishka, you touched on the trust there, and your article focused quite heavily on the use of trust in estate planning. So why is it that you advocate for a trust to be an integral part of that whole planning process?
A trust, especially an inter vivos trust, can be set up in such a way to continue years and years after your death. Now, the main reason is you use this trust is to protect your assets. So, for example, I always use this example, but a property in a deceased estate will have to be transferred to a heir or sold in the event that there is not enough cash in that estate. This will incur costs, especially transfer costs. But when it's in a trust, it's not necessary at all. On the death of a trustee, he or she can be replaced and they continue. So the legacy are being preserved for future generations.
Now, Marishka, I think a lot of people don't understand how these things work because, it's not something we taught at school, how to use a trust and everything. So how difficult is it for someone to set up a trust, and can anybody do it?
Personal opinion, after the master passed a directive in 2017 that basically makes it compulsory to have an independent trustee, I would say it has become much less difficult and anybody can do it. You now have the independent trustee backing that advises you on all transactions. And even if you do not know how a trust works or where to begin, we are able to start the process and guide you step by step. So really anybody.
And now you mentioned the, future planning and future legacies. What actually happens to your trust if you pass away?
Well, I'm going to look specifically at when a trustee passes away. We ask for the death certificate as well as the last will and testament. So the death certificate we ask for, we need to lodge this with the master in order to remove the deceased on the letters of authority. The last will and testament to see whether the deceased nominated a replacement trustee. We then contact that replacement trustee for his or her information, and then we compile documents that will add this person as the new replacement trustee. So this is in the event when they nominated a replacement in their will. In the event that the deceased were also authorized in certain transactions, we now authorize another trustee by way of resolution, and transactions can really continue as normal.
And Marishka, how long does it typically does it take an estate to be wound up if the correct structures are not in place?
Overall, even if it is in place, I would say the master takes a while to provide that letters of authority. And in the event that there's no structure, or let's say there's no will, it will take a bit longer. So when there's no will, you will have to provide extra documentation like the nomination of executorship. And there's a lot more extra information that you will give to the master. So it might take a while.
And then you mentioned a little bit earlier about, upon death, there's a whole lot of costs for the executor and this and that. Do you know sort of a rundown of what those costs would be for a winding up an estate?
Yeah. So cost for winding up the estate, you are looking at executors' fees. That's usually 3.5% plus tax on that. You have after death fees, that's 6%. So these type of fees are the ones where you have a property in your personal name and there's still a rental agreement in place. Now that money now goes to the estate late account, and you can ask 6% after death until the day that you finish up the deceased estate.
Good. And then just for this last question, if there is a trust structure in place, how does that affect the cost for your estate winding?
So, the rule is the less that's in your deceased estate, the less fees. So the smaller that your deceased estate is going to be, the less fees there are. And, just think about the property that's at this stage in your personal name. If it's worth $1 million, your estate it will grow with $1 million. So just by removing that R1 million property to a trust, it will make it a lot less.
It seems like a no-brainer for a lot of us to sort of take on the structure. So Marishka, thank you so much for imparting all of this information and knowledge to our viewers in a short little bit of time. But if you are viewing, want to make sure that you are one step ahead of the rest, then you are most ideal suited to be a savvy investor. And if you are, then you need to make sure you register for our free online training, which is taking place this weekend. Well, all you have to do is register and we will give you all that information. You'll have the whole weekend to watch our online training and you can learn the best structures of how to become an investor, how to make sure your estate is ready for in the event of you passing, and how you can make sure that you are looking out for your future generations. So it's a few hours of your time to learn how you can become financially free and create that generational wealth for your children, their children's children, and it goes on forever. So the link to that registration is in the description below. So make sure you click there and register today. But Marishka, thank you so much for your time. We really appreciate it. And we hope to chat to you again very soon.
Thank you so much.
Great stuff. Thanks so much, everyone. Thanks for viewing, and we will see you next week. Bye-bye.